So you have three main options for getting international patent protection. Option 1 is using the Patent Cooperation Treaty, or PCT. This is the most popular choice, and we'll spend the most time on it. Option 2 is using the Paris Convention. This is direct foreign filing, and it's faster, but it gives you less time to decide. Option 3 is using regional patent systems like the European Patent Office, which lets you file one application that covers multiple countries in a region. Let's break down each one. The Patent Cooperation Treaty is administered by the World Intellectual Property Organization, or WIPO. It has 157 member countries, so it covers most of the world's major markets. Here's how it works. Instead of filing separate applications in 10 different countries, you file one international application with WIPO. If you're in the U.S., you usually file through the U.S. Patent and Trademark Office, the USPTO. Sometimes you'll file elsewhere for some strategic reasons, and I'm not going to go into those today. This single PCT filing establishes an international filing date that's recognized in all member countries. Think of it like planting a flag that says, "I was here first." Now, here's the key benefit. The PCT buys you time, a lot of time. Normally, under the Paris Convention, which we'll get to in a minute, you have 12 months from your first patent filing to file in foreign countries. That 12-month window can feel really tight, especially if you're still figuring out your marketing strategy or trying to raise funding. The PCT extends that window to 30 or 31 months, depending on the country. That's an extra 18 to 19 months to make decisions about which countries to pursue patent protection in. During that time, you can test the market. You can pitch to investors. You can see if there's actual demand for your product in Europe or Asia. And then, when you're ready, you enter what's called the national phase in the specific countries where you want patent protection. Here's a really important point. The PCT application does not grant you a patent. I see this misconception all the time. People file a PCT application and boom, they think they have an international patent, but that's not how it works. The PCT is a filing mechanism. It's a way to establish your priority date and buy time. At the end of the PCT process, you still need to enter the national phase in each country where you want protection. That does mean filing applications with those countries' national patent offices, paying their fees and going through their examination processes. So the PCT doesn't replace national filings, it delays them and streamlines the initial process. Let me give you the key benefits of the PCT route. Benefit number 1 is time. You get 30 to 31 months instead of 12 to decide which countries to file in. That's huge. Benefit 2 is that there's a single filing, one application, initially in one language, usually English, and one set of fees to start. That's much simpler than filing in, say, 10 separate countries simultaneously. Benefit 3 is you get an international search report. WIPO conducts a search of prior art worldwide and gives you a preliminary opinion on whether your invention is likely to be patentable. This is incredibly valuable. If the search report comes back and says there's very similar prior art, you might decide not to spend $50,000 on national phase filings. You may even get that report before your U.S. application is examined, so it can help you prepare for potential refusals in the U.S. Now, if it looks good, you can move forward with more confidence. Benefit 4 is flexibility. When it's time to enter the national phase, you choose which countries to file in. You can file in 5 countries, 10 countries, or just one. It's entirely up to you, and you get that extended period of time to decide what's best. Now let's talk about option 2, the Paris Convention. The Paris Convention is actually older than the PCT. It was established in 1883, and it has 177 member countries. Here's how it works. You file your first patent application in one country, let's say the United States. That filing establishes your priority date. Then, within 12 months of that priority date, you can file patent applications directly in other Paris Convention member countries. Each of those foreign applications will be treated as if it were filed on your original U.S. filing date. So if you filed in the US on January 1st and you file in Japan on December 1st, 11 months later, your Japanese application gets the benefit of that January 1st priority date. That means any prior art that came out between January and December doesn't count against you in Japan. So what's the difference between the PCT and the Paris Convention? The key difference is time. The Paris Convention gives you 12 months. The PCT gives you 30 to 31 months. The other big difference is upfront complexity. With the Paris Convention, you're filing in multiple countries at the same time. Each country has its own forms, its own language requirements, and its own fees. So within that 12-month window, you need to coordinate with patent attorneys in every country where you want to file. That's a lot of moving parts. With a PCT, you file one application. Then 30 months later, you deal with the national phase filings. It's the same work eventually, but it's spread out over time. If you know exactly which countries you need from day one, maybe you have manufacturing contracts in Germany and distribution deals in Japan, the Paris Convention can be faster and potentially less expensive upfront because you skip the PCT filing fees. If you only need protection in one or two foreign countries, the Paris Convention can make sense. If you need patents granted quickly for some reason, maybe to close an acquisition or satisfy an investor, direct filing can be faster because you're not spending that extra year and a half in the PCT phase. Option 3 for international filing is using regional patent systems. Some regions have consolidated their patent systems so that you can file one application that covers multiple countries. The European Patent Office, or EPO, is the biggest example. You file one application with the EPO, and it can cover 38 plus European countries. After the EPO grants your patent, you validate it in the specific countries where you want protection. So you might validate in Germany, France, the UK, and Italy, but skip smaller markets to save on fees and translation costs. ARIPO, the African Regional Intellectual Property Organization, covers 19 African countries with one application. The Eurasian Patent Organization covers Russia and several former Soviet states. These regional systems can be accessed through either the PCT or Paris Convention routes, so you might file a PCT application, then enter the European regional phase instead of filing in individual European countries separately. Avoid those legal horrors and keep rocking your IP. If you're considering international patent protection and want to talk strategy, book a consultation at kingpatentlaw.com. Quick reminder, this information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney.